Have you ever clicked I agree without actually reading the terms? Well, you've just entered into a contract. But do you know what that means? G'day everyone, LawBlender back again. Your friendly neighbourhood lawyer here to mix the law and technology until it's understandable. Welcome to the LawBlender series Legal Term Explained, Contract and Civil Law Edition. Today, we're diving into the world of contracts. So, what, you ask, exactly is a contract? Simply put, it's a legally binding agreement between two or more parties. Think of it as a legally enforceable promise. It doesn't have to be a big formal document, although it can be. It can be a verbal agreement, a written document, or even an exchange of emails. The key elements of a contract are offer, acceptance of that offer, something of value exchanging between the parties, something we call consideration, and an intention to be bound by a contract. So why are contracts so important? They're the background of business and much of everyday life, from buying a coffee to renting an apartment to performing major business deals. Contracts protect your rights and ensure everybody sticks to their agreements. They provide certainty and predictability in our interactions, largely allowing our system to work. Without them, the world would be legal chaos. Way more chaos than it already is. In the United States, contract law is primarily governed at the state level through common law principles and some state-specific statutes. There isn't a single federal contract law, making a bit of a patchwork. However, the Uniform Commercial Code, or UCC, provides a common set of rules for the sale of goods. The key elements are similar to what we discussed before: offer, acceptance, consideration, a meeting of minds, and showing a mutual intent to create an enforceable contract. For example, let's say you buy a used car from a private seller in New York. While you mightn't have a fancy written document, the exchange of the car for money is considered a contract. If the car turns out to be faulty and the seller misrepresented it, you might have legal recourse under New York contract law. This highlights the basic elements of offer, acceptance, and something of value changing hands. In Australia, contract law is largely based on common law principles, developed over time through court decisions and influenced heavily by English law. There's also some specific legislation that applies, such as the Australian consumer law and fair trading protections from the individual states. Again, the same core elements, offer, acceptance, intention to create legal relations, and consideration form the background of what a contract is. Much like the US, the contract can be verbal or written, and it's not always necessary for it to be a formal document. For example, imagine you're buying a new phone from a major retail store. The moment you pay and the store hands over the phone, a contract is formed. If that phone breaks down within a warranty period, the Australian consumer law implies warranties into that contract, giving you the rights to repair, replacement, or refund. This is an example of how legislation and common law work together within the Australian context. While both America and Australia share similar common law roots in contract law, a key difference lies in the application of consumer protection legislation. Not every contract is subject to this. However, the Australian consumer law is a strong national law, providing a higher level of consumer rights that is uniform across the states. There is a lot of similarity, such as both are based around common law principles of contracts. Another notable difference is that in Australia there's greater emphasis on implied terms in contracts, especially in consumer transactions. In the United States, the concept of caveat emptor or buyer beware still holds more weight in some states than others, although consumer protection laws are evolving. So now it's your turn. What are your thoughts? Have you ever had a contract dispute? What do you think is the most important thing to consider before entering into agreement? Share your experiences in the comments below. Alright, so here are the key takeaways to remember about contracts. 1. A contract's a legally binding document. Understanding what you're agreeing to is paramount. Always read the fine print and ask questions before signing anything. 2. Contracts can be verbal, written, or implied by conduct. However, having something in writing is always the best option, as you have something definitive to fall back on. There are legal systems in both Australia and the United States that enforce contracts, so you have avenues for recourse if a party fails to comply with the contract. And lastly, if you're dealing with a complex contract or you're unsure about your rights, always seek professional legal advice. It's worth the investment to ensure you're protected. That's Contract 101 explained for you. We've explored everything from the basics, the law in the USA and Australia, and how the core concepts are similar between the two. If you like this, you might want to watch the section on mediation in the upcoming series playlist. Up next, we'll be tackling breach of contract and what that means. If you found this video helpful, please give it a thumbs up and subscribe to the channel for more easy-to-understand legal breakdowns. Got any other legal terms you'd like us to explain? Comment below or check out LawBlender.com. So this is LawBlender reminding you that when it comes to contracts, knowledge is power. Stay informed, and I'll see you next time.